Hello, humans, and welcome to another episode of Gen X Gamer. We have the legend Karl Jobst versus the video game player of the century, if not infinity, Billy Mitchell. For us that follow this stuff, for us that love retro gaming and gaming in general, this is our trial of the century, right? Very few things go to trial. So for those of you who follow this kind of stuff, hopefully this is entertaining for you. Let me tell you what I did. First of all, let me tell you, I don't have a degree in law. I have a degree in BS. No, my college degree is not in this field at all. But this is for your entertainment only, okay? And what I've done is I've gathered information from around the internet and fed it to the AI so it can come up with, an educated opinion, I guess. AI makes errors. This could be not 100%. You guys can research it on your own. But see, I've seen a lot of videos. That kind of dance around a lot of issues, but they don't get to the requirements. Like, what is the bar that Billy needs to meet? What is the bar that Karl needs to meet? What tends to happen in this kind of court? I'm in the US. I have no idea of Australian law, how that works, the freedom of speech laws. I don't know any of that, right? So I have to rely on what we've read so far in Perfect Pac-Man. So I want to add a little bit more, right? So you guys can see number one, and it'll be the first part of the video will be, okay, what happens in this kind of case where you have a superior lawyer on the plaintiff side, just a regular barrister on Karl Jobst's side. What is it? A Queen's counselor, I guess they call it, on Billy Mitchell's side. What happens? What cases come to trial? What bars do they have to meet? Just general information that I don't get from videos. They just give opinions, but that doesn't really tell us, right, what these people need to accomplish in court. Let me tell you, I thank God every day for egos and money. Egos, money, and bad decision, because they provide a lot of entertainment for us. So guys, please enjoy. Some of what you're going to see here are going to be the basis of my next video. I have finals right now, so I have to concentrate on that. But hopefully this weekend, I'll put out another video just regarding Karl Jobst. There's plenty of videos on Billy Mitchell, right? Billy Mitchell's side has been analyzed back and forth and broken down. But I think it's a more constructive conversation to see how we got to this place. And I'll explain to you why in the video. I think there's space for both of them. We need a villain in the video game space, right? Billy Mitchell fits that part to a T. I can tell you, for those of you who are a little bit younger, that I don't know any old guys like me, right? Most guys that are old retro gamers like me have no problem with Billy Mitchell, and they kind of lean into that persona that he has as the villain of the community, or the bad boy, whatever you want to call him. They have no problems with it. And there's always a need, especially in this day and time in the US, I don't know if everywhere around the world, but we need free press, free independent press. And, there's so much to talk about here, but I wanted to start with this foundation here so we know how this game is going to be played, or more or less get an idea. Again, I'm not a lawyer. This is not a law program. This is pure entertainment. But it should give us a guideline of what the judge is going to be looking at. Now, with that said, let's get it going.
In Australian defamation law, cases are decided by evaluating whether the plaintiff has proven all the required elements of defamation and whether any available defences raised by the defendant are valid. Here's a breakdown of how these cases are handled and whether liability and legal costs can be shared. Hasher 1. How cases are decided. Australian defamation law is governed by the Defamation Act 2005, which is applied similarly across all states and territories. To succeed, the plaintiff must generally prove 1. Publication. The material was communicated to someone other than the plaintiff. 2. Identification. The plaintiff was identifiable in the publication. 3. Defamatory content. The publication damaged the plaintiff's reputation, exposing them to ridicule, hatred, or contempt. Once these elements are proven, the burden shifts to the defendant to raise one or more valid defenses, such as truth, justification, the defamatory material is substantially true; honest opinion, the statement was an opinion, not a factual claim; qualified privilege, the defendant had a duty to make the statement, and the recipient had an interest in receiving it; triviality, the publication was unlikely to cause significant harm to the plaintiff. 2. Is liability all or nothing? In Australia, defamation liability is typically binary. The defendant is either liable or not liable. There is no concept of partial liability, like comparative fault, as seen in some tort cases. A court must determine whether the plaintiff has fully proven the case and whether any defences apply. However, the amount of damages awarded can vary based on the extent of harm caused. The court does not typically say the defendant is partially liable, but can award lower damages if the defamation's impact was minimal or if mitigating factors, such as a prompt apology, were present. 3. Who pays legal costs? In Australia, the loser pays rule generally applies in defamation cases, meaning the party that loses the case is typically ordered to pay the legal costs of the winning side. However, courts have the discretion to modify cost orders based on the circumstances. For example, if the plaintiff only wins on some issues but loses on others, the court may order each party to bear their own costs, or only award partial costs to the plaintiff. If the case could have been resolved earlier, e.g. the defendant offered an apology or settlement that the plaintiff unreasonably rejected, the court may penalise the plaintiff by limiting their cost recovery. 4. Can a partial award be made with split legal fees? While the defendant cannot be found partially liable in the strict sense, courts can adjust damages and legal costs to reflect the outcome. For example, the court may award the plaintiff nominal damages, a small amount, if reputational harm was minimal. In cases where both parties acted unreasonably at different stages of litigation, the court may order a split cost arrangement or cap the amount one side must pay. The ability to split costs or limit them reflects the court's effort to discourage unnecessary litigation and promote fairness, but it is used judiciously and on a case-by-case basis. Summary. Defamation liability in Australia is typically all or nothing. Either the defendant is liable or not. There is no partial liability, but damages can vary based on the harm caused and mitigating factors. Legal costs usually follow the loser pays rule, but courts can order split or partial costs if the circumstances warrant it. Judges have discretion in awarding damages and legal costs, allowing for some flexibility to promote fairness, especially if only some claims succeed or if a party behaved unreasonably during litigation. Yes, it's accurate that in Australia many defamation cases do not make it to court. Here's an overview of the dynamics at play. 1. Prevalence of settlements and threshold for filing. Most defamation claims in Australia settle before reaching court for a few key reasons. Threshold of merits. Many potential defamation claims don't meet the legal standards required for a strong case. Defamation is complex and difficult to prove without a clear, reputationally damaging statement that directly references the plaintiff and lacks any valid defences. Costs and risks. Litigation is expensive, especially for defamation cases, which often require lengthy court proceedings and expert testimonies. The potential for high costs, with the loser typically covering both parties' legal fees, discourages weaker claims. Alternative dispute resolution. Parties often prefer to resolve issues via negotiations, apologies, or out-of-court settlements to avoid the unpredictability and public nature of a trial. For those cases that do meet the legal standards and proceed to litigation, reports suggest plaintiffs prevail more often. This is largely because plaintiffs are typically well-advised and file cases with high confidence in their likelihood of success. Defendants may struggle to successfully argue defences, especially if the defamatory statement lacks a basis in truth or reasonable opinion. 2. Disparity in representation. Queen's Counsel versus regular barrister. When a plaintiff is represented by a Queen's Counsel, QC or Senior Counsel SC, and the defendant by a regular barrister, there can be significant tactical and psychological implications, although this does not automatically determine the case's outcome. Here's what typically happens. Strategic advantage. A QC is generally a senior barrister with extensive trial experience, recognized for high competence in complex cases. Having a QC can lend the plaintiff an advantage in both courtroom strategy and cross-examination strength, potentially putting the defense at a disadvantage if their representative lacks equivalent experience. Perception and leverage. A QC's presence might increase the pressure on the defendant to consider settling. The prospect of facing a more seasoned adversary in court can make the risks of an unfavorable judgment more apparent, often incentivizing defendants to seek an early resolution. Resource disparity. QCs usually come with higher fees, which can reflect a broader legal resource backing. For example, a plaintiff with a QC might have additional resources for pretrial investigations, more specialized legal support, and stronger evidence presentation. That said, the presence of a QC does not guarantee a plaintiff's victory. Courts decide cases based on the evidence and legal arguments presented, not the status of the representatives. Yet, the influence of an experienced QC in navigating procedural intricacies and in persuasive argumentation can undeniably strengthen the plaintiff's position. Nasha 3. Typical outcomes in such scenarios. Hypothetically, if a plaintiff has a QC and a defendant only a regular barrister, higher likelihood of settlement. The defendant may be more inclined to settle, particularly if the QC's involvement indicates the plaintiff's serious commitment and strong legal strategy. Courtroom dynamics. If the case proceeds to trial, the defendant's barrister might face challenges in matching the QC's expertise, particularly in handling complex points of law or in cross-examining witnesses. Cost orders. Should the plaintiff prevail, the defendant could face significant costs, including the higher fees associated with a QC. Ultimately, while having a QC does add a layer of sophistication and pressure, it's not a guarantee of success. Australian courts are generally impartial to the type of representation and focus on the legal merits, evidence, and defences presented by both parties.
New videos every Monday and Sunday. Thank you for joining me on another episode of the Gen X Gamer. Remember to like and subscribe, click that notification bell, and remember, never ever be afraid to be happy. I'll catch you on the next one. Take care.